Dang, what a day. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, you guys, we have some new Idaho docs. I have been able to scroll a little bit throughout the day before my internet luckily came back on. It is after 7 p.m. right now, and it just came back on a few minutes ago. But I do want to say thank you again to Melissa Jade. She sent me a few screenshots of the new documents. So honestly, I was really just hoping this internet would come up because there is a lot of documentation here. And we need to go ahead and get started on this so that we can try to at least stay up to date on this case. Okay, so the last document that we went over was the state wanting the next motion hearing to happen in this case to be sealed. And a lot of people were like, why? Why? Are you afraid you're going to let some more secrets out? Because at this point, the state is being accused of doing a lot of things. And now Bill Thompson has his own little starring role in a PowerPoint presentation that is now part of the public record for the court record. And yeah, he's not happy about it. So a lot of us thought that was the reason. Now, granted, whenever I went back over the document, and this is what I stated in my video about it, okay, as much as I want to see everything, it made sense to me because everything that they were going to be going over in this hearing are all things that technically are still sealed in the case. So it did make sense to me for him to want it sealed, even though I don't want it sealed. You know what I mean? Like, I understand why he wants the hearing to be a closed session because everything they're discussing is sealed documentation, not public access, not public record. But I want to know. And at this point, all this insanity that's happening in this case, the gag order is just doing more harm than good. I'm pretty positive that everyone agrees on that. Now, this is that document right here, this motion to close hearing. That's the last one that we went over. Now, I haven't had the chance to see what order that we need to actually be going through these with, so we're just going to go through them as they're filed. This is the motion to temporarily seal the Exhibit 1 to the state's response, and that would most likely mean that that's for this. This is the state's response to defendant's fourth motion to compel discovery. And this was actually, the fourth motion was when? Because the fifth motion is right here on 415. When was the fourth one? 312. So we are very close to May, and it was all the way prior to the survey problem that this fourth motion to compel was actually filed. Now, this is their response to it. And then, of course, we're going to have this motion to temporarily seal the exhibit that they have attached to the document. So we can close that one off. And we're going to go ahead and read this one and see if it has any interesting information. And honestly, I just skimmed through really, really quickly off camera. And it's literally just a list of page document titles. That's all it is. And then whatever that is that they are attaching that is sealed. And this is into, okay, this says the state incorporates the following responses as fully set forth at this point. Okay, so anything that's on this list is stuff that is I guess not important, not needing to be discussed, and have been responded to at this point in full with nothing further, I guess, until they pop up as discussion in court itself, probably. Now, this is the one that I saw populating on Twitter earlier today whenever we were at the restaurant and I was scrolling. I saw this and I was like, oh, well, this is going to be interesting. Okay, so this is for them to unseal parts of the IGG. Now, I don't know which one of these filed first. That's 11:57 a.m. and this one, they're both 11:57. Okay, so I guess we're just going to start with this one. This says TYA. Thank you, Anne. Maybe? Anyway, or maybe A. Taylor, A-T-Y. I don't know. I don't care how they title things. Okay, so this is the motion to allow defense investigators to review IGG materials. Whatever the IGG materials were that the state claims to have had in their possession from the feds, because the feds are the ones that apparently completed this entire thing, right? Right? Okay. Whatever the state had in their possession was then given over to Judge for an in-camera review, which just means that he went in chambers and he looked over stuff himself. Now, I remember him saying something about possibly needing everybody to meet together in a public way and have people come in to help them explain stuff. But that's not really what happened, unless it happened just between them and it wasn't anything that we, the public, knew about, which is a huge possibility that they just hey, can we kind of figure this out? And they got together and maybe they figured it out. I don't know. Because Judge did make it sound as if when it comes to this sciencey stuff, he might need a little bit of help to understand it, which is understandably so. But none of that happened that we know of. But we do know that only a portion of whatever Judge was going through was actually allowed to be given over to the defense. Not all of it, which means that there's portions of evidence that Judge has seen that the defense has not, which I don't know if I like, because that's a bit not normal, right? So to me, this means that the portions that were allowed, the portions of evidence that were allowed to be seen by the defense now wants their own IGG investigators to do their own shit to it. So I wonder if this is where Vargas comes back in. It's possible. We don't really know the situation with Vargas. I know that she went on a couple of channels and did some interviews that she probably shouldn't have because of her involvement in this case, okay? But we don't really know what her stance is in the case anymore. And as far as we understand, her statements have not been recanted. None of those things. We know that Thompson sent feds over to her house after that day that she was on the stand to talk, but that didn't stop her from them jumping on YouTube and talking to a couple of channels about a couple of things. So, I don't know, but this could be where somebody like Vargas, or maybe Vargas herself, would come back in if this does get approved. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby moves this court to allow defensive investigators to review IGG, investigative genetic genealogy materials. This motion is made to protect Mr. Kohberger's state and federal constitutional rights, including the 5th, 6th, and 14th Amendments to the United States Constitution, as well as Article 1, Section 13 of the Idaho Constitution. This court previously entered an order allowing specific experts access to review the protected IGG materials. At the time of the order, the defense team requested that its investigators also be allowed to review the protected IGG materials. The court denied defense investigator access, but did indicate that it would be willing to reconsider the request. The Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. This right is safeguarded, in part, by constitutionally guaranteed access to evidence. Mr. Kohberger is requesting that the court reconsider its decision and allow the defense team investigators to review the protected IGG materials. A hearing on this matter is requested to explain why the current order needs to be advised. The hearing does not need to be sealed and is expected to take approximately 15 minutes. So Ann Taylor wants this open. Well, it's Masoth that seems to have been the one that is writing and signing this, but they want this to be completely open. I don't know if that means they want it to be live streamed to the public, or if they just want us to be able to access this information afterwards. I don't know, but this basically is saying pretty much what I thought it said. They want more information on the IG, and they want their own people to be able to look at the information. Now, what I'm curious about is if they're wanting them to reconsider what was given over. Because I know that some of it is still protected, but is the stuff that the defense was allowed to view still considered protected IGG materials? Or what is that? I don't know if that means they're asking for more of it to be given to them, or if they just want to be able to allow their own investigators to review the stuff that they were handed. I guess we'll find out later. Now, this is attached to this IGG thing, okay, and we talked about this one before we started reading the last document. This is entitled Motion to Unseal Parts of IGG Materials. Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby moves this court to unseal the IGG materials sealed by this court's order signed on 12/29 of 23, except for the individuals on the family tree or found via the IGG on the grounds that this information should be made public and does not meet the requirements for sealing under ICAR 32. This court previously entered an order allowing specific members of the defense team, including specific experts, access to review the IGG materials it ordered disclosed. The court has indicated during hearings its concern was the privacy of individuals on the family tree. The defense shares that concern and takes no issues with it, which is kind of what I said too. I was like, we the public don't need to know all of the family members that are on this family tree. But then again, like nobody can be, put at fault or anything for being related to Bryan Kohberger, at least in reality, like in the way that you would want reality to work, right? But then again, we also heard that like throughout all of this, in the beginning of all of this, that both of his sisters apparently lost their jobs just because they were his sisters, which is so screwed up. So yeah, I mean, I totally get why they want privacy, but we the public don't need to see none of that. Only thing that we need to be like aware of is that the defense has seen everything that's there. That the defense is getting treated fairly and is able to see and able to research all of the evidence that is being used against their client. That's all that we want. Anybody who's really here for justice, okay? I understand wanting to know every little bitty detail. I get that, but that's not what needs to be the fight here. It doesn't need to be the fight for us to get all of the information. We just need to make sure that the fight's being fought fairly, okay? That's all I'm saying. The defense does not object to the sealing of the rest of the information that has been disclosed. There is simply no legitimate reason that the way the IGG procedures in this case took place should be shielded from the public. Oh. So what they really want is like all of the ways that they apparently got to Bryan to be out there to the public. But we also know that they're really worried about like the public knowing that they violate our privacy rights. Because you have to remember, something that we've been learning along the journey of this case is that they use these ancestry and these genealogy platforms against our privacy rights. And they know how, and they know the loopholes to use, and they do all kinds of things without your permission, without you even knowing. There's a lot of information that has come out in this case. And a lot of this has been, they don't want us to know their secrets. Okay, well, it's too late. Cat's out the bag. Suck it up. The court provided no authority for sealing those materials. Those materials have been sealed in this case to protect the right to a fair trial. There is simply nothing unfairly prejudicial about the way in which IGG was carried about the state and its associates in this case. Nothing unfairly prejudicial? There is simply nothing unfairly prejudicial. That's interesting coming from the defense. That's coming from the defense, right? Here comes now Bryan C. Kohberger. Okay. There is nothing unfairly prejudicial about the way in which IGG was carried about the state and its associates in this case. Interesting. In point of fact, the way in which IGG occurred in this case has been made public in other cases. See State versus Hartman. Oh. Interesting. And then it talks about the ingenious and dystopian technique police used to hunt the Golden State Killer, and it gives an article that dates back to April 28th of 2018. Yeah, the Golden State Killer was the very first time that Ancestry DNA solved like a crime and put it on the map. I don't know if it's the first time it ever actually solved a crime, okay? But when it comes to like a big thing that put IGG and Ancestry on the map for crime solving, it was Golden State. There's no one that can argue that. Aspects of the IGG investigation in this case have already been leaked. How police actually cracked the Idaho killings case slate. January 10th of 2023. That is like 11 days after the arrest. Oh, well, looks like we have an article to go over after this, guys. This court's order is being abused by the state and the FBI to hide how IGG was used in this case, because what the FBI did violated its own rules and the rights of privacy genetic genealogy companies have promised. I told you, it's a huge concern. They don't want us to know. These companies especially don't want us to know what they're allowing certain law enforcement agencies to get away with, because it's already been proven that all of these little loopholes and all of this boo-boo that they pull has been very well known for quite a while. Not only is there no authority to protect the FBI and the state in this matter, this refusal to permit Mr. Kohberger to expose this to the public is a clear violation of his right to a public trial. Yeah, we've talked about that too. And it goes all hand in hand with they don't want their secrets out. It seems like a lot of this case is all about secrets. Whether it be things that, you know, according to Steve, the families don't want coming out, but no will anyway. You know, things that are muddy, right? Then we have the secrets of all of the things that the state's doing wrong, okay? And I'm not going to sit here and act like the defense don't have their own secrets, because I'm not stupid. And then we have all of the secrets surrounding the reason for the university's involvement and leadership in something that happened off campus. This case is full of secrets. A hearing on this matter is requested if necessary. The hearing does not need to be sealed and is expected to take approximately 30 minutes. So they're basically like, I don't want to have this take forever, and there don't need to be no privacy, no secrecy, boo-boo. Let's just get this over with. It ain't going to take but a few minutes. Yeah, like this is all just insane that this is all still happening any freaking way. Okay, so now we have an objection to the state wanting that motion hearing to be closed. Like we mentioned before, that's the last update that we did before this video, was the prosecution wanting the next hearing closed. And the defense says, oh, nay, no closing stuff. We're over all of that. Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby objects to the state's motion to close the hearing to compel on May 14th of 2024. That's literally like 2 weeks away. The grounds are that Mr. Kohberger has a constitutional right to a fair and public trial. Okay, but this isn't trial yet. No reason exists to prevent him from a public pre-trial proceeding, a proceeding to ensure fairness and access to the state's information. Yes, I agree. Okay, yes. Further, the state has made no showing that the hearing should be closed under IAR 32. There is simply no legitimate reason that a motion to compel discovery should be shielded from the public. There is simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents. That's the second time that she is basically claiming that they are abusing their authority, they are abusing these laws, and they are just not doing things correctly. And that's a really very specific accusation, that's all I'm going to say. Including the FBI to hide how discovery is being withheld in this case. Testimony and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, other law enforcement agents, and the state in this matter, that request to deny Mr. Kohberger an open hearing is a clear violation of his right to a public trial. The state has failed to provide all the requested items that were asked for in the defense's supplemental request for discovery to support the charges against Mr. Kohberger. Thus, the defense has had to file its fourth and fifth motion to compel. It is not lost on Mr. Kohberger that the state is asking for a scheduling order to obtain information from the defense to be used in support of our motions to compel the state's discovery. However, Mr. Kohberger suggests a dual deadline for both the prosecution and defense to file notice of witnesses, exhibits, experts' reports, or other evidence relied upon at the fourth and fifth motions to compel by May 7th, 2024. Response disclosures by both parties should be due May 10th of 2024. So instead of staggering things the way that it had been, where's that at? That'll be, oh my goodness. That's the scheduling order stuff that they're wanting to have changed, because whenever the state requested for this hearing to be sealed, they also put a couple of other dates in here, and we didn't go over these because all of these normally get changed anyway. So we didn't go over the dates on this very specific situation. Okay, but I will go ahead and let you guys see what it was right here. So what they wanted was that the defense file their witnesses, experts, expert reports, or other evidence by May the 3rd, and that the state then have like until the 10th to respond or something like that. So doing it this way, the way that the defense is wanting it done, to where both sides file stuff on the exact same dates and it's not like staggered deadlines. I mean, honestly, it makes more sense at this point. Like, can we get this done and stop wasting all this extra time for no reason whatsoever, right? But it's also interesting that the defense is the one asking for this to sort of like, can we speed this up by kind of like just putting our deadlines together? Because they're the ones who keep asking for additional time. Maybe they feel like they're finally ready, though. I mean, at this point, maybe she might feel like they're ready to go to trial. Now, this is the second order to augment the record that we've gotten from Bryan Kohberger's team. The first one was filed back on, let's see, where was it? Right here. Motion to seal defendant's motion to augment the record is basically like where we first saw it on March the 6th of 2024. But if you go back and you look, you don't see the actual like document situation. We did go over this though, whatever the whole augmenting the record thing popped up the first time, but now we have it again and there's no details. This is just like being approved. So is this the same one that we just said was on March 6th? Okay, it looks like it is. Okay. The court having before it the sealed stipulation to defendant's motion to augment the record and good cause appearing now, therefore, it is hereby ordered that the court shall augment the record with the documents attached to the defendant's motion to augment the record filed with the court on 3/6 of 24, and that they shall be made a court's exhibit and part of the official file. It is further ordered that the court shall augment the record with the documents attached to the sealed stipulation to defendant's motion to augment the record filed with the court on 4/22/24, and they shall be made a court's exhibit and part of the official file. So where's that? Was this like missed by me completely, or what's up with this? Okay, because this was filed last week on the 22nd. How did I miss this one? Where was this even sitting? Oh, yep, I sure did. Because we talked about how the survey got to continue, and then we talked about the state wanting to have this be a closed hearing, and we did not talk at all about this document. Okay, I guess we're going to have to backtrack for a second. Comes now Bryan C. Kohberger by and through his attorney, N.C. Taylor, public defender, and with no objection from the Latell County Prosecutor's Office, and hereby moves this court for an order to seal the stipulation to defendant's motion to augment the record pursuant to ICAR 32. Then it says this motion is made pursuant to ICAR 32 because 1, the documents contain facts or statements that might threaten or endanger the life or safety of individuals, and 2, it is necessary to preserve the right to a fair trial, and 3, disclosure would constitute an unwarranted invasion of personal privacy. All of the same excuses that they always give us for why they want to seal things. And instead of there being no objection, it just says so stipulated. I don't really know if that like even actually matters, but I'm curious as to what these documents are. Because we had a situation like this, and I believe that I brought this up when we talked about this back in the beginning of March in the Scott Peterson, Lacey Peterson case, where there was like I want to say 10 to 12 documents that missed the scans when it came to the documentation that was given to like the jury and for trial itself. And part of these so-say missed scanned documents was like stuff that people would possibly consider exculpatory because it was information about the other people that saw Lacey Peterson walking the dog after Scott left that morning, including information from the mailman. So you have to be really careful about these things. I'm really curious as to what this is because it's got to be important. If they deemed it enough to be like, hey, we've got to add this, we cannot get away with going to trial and handling this case without this information. Super curious. Now, this is just the order stipulating that all of these things be sealed. That's all this is. So whatever this is, we're not going to find out until trial, hopefully. They'll mention it if this gets brought up as evidence, whatever is in these documents. If it gets brought up as evidence, they'll be like, these are the documents that were added to the file with the augmented record motion that was blah, 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 whatever. Like, I'm sure they have to go in and give specifics and all that stuff, right? Okay. So there's 3 more left. Okay. This is the one that me and Melissa Jade were texting back and forth on. So I already have some like predetermined thoughts on this document, okay? This is the state's response to the alibi information that we got last week from the defense team. The alibi information that says that, you know, we already knew that he was driving around, but now they're giving us more of like a generalized area, saying that it was south of Pullman and west, not east where Moscow would be. And I mean, I don't disagree with some of the things that are being said in this. I don't. But I also have my rebuttal like I always do. So let's just go ahead and get started with this one. Response to notice of defendant's supplemental response to state's alibi demand. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following initial response to the notice of defendant's supplemental response to state's alibi demand filed herein on April 17th of 2024. At the outset, the state incorporates by reference as it fully set forth at this point those portions of the state's July 27th, 2023 motion to compel notice of defense of alibi or alternatively to bar certain evidence to the extent that it relates to the adequacy and timeliness of defendant's alibi notice. The state respectfully submits that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19-519, which provides that the defense shall state the specific, underlined specific, place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Emphasis added. The defendant's April 17th, 2024 submission minimally adds to the alibi notice dated July 24th of 2023, meaning the information that they gave didn't really do much to add any new information or give any luster to the information that we were already given. There's not any more here that gives us any more detail that we can use when it comes to an alibi. And I'm not going to sit here and say that the state is wrong in claiming that, because they're not wrong. The defendant states that he was driving around during the early morning hours of November 13th of 2022 and drove throughout the area south of Pullman, Washington, west of Moscow, Idaho, including Wallaway Park. With the exception of the reference to Wallaway Park, which is new, the defendant is offering nothing new to his initial alibi that he was simply driving around during the morning hours of November 13th of 2022. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho during the early morning hours of November 13th of 2022. Right. That part is basically being concreted down as a fact by both sides. Because when it came to the previous alibi information, And I want to say that it even says that he was driving around before midnight, which I need to go back and look through all of that, which is something that we're going to do, something I want to do, something hopefully we get to where we go back and we pull all of it. Because I do remember, and I'm hoping I'm remembering this correctly. I'm sure if I'm not, somebody will let me know in the comments. But in the document, I swear it says he was driving around before midnight, and that left a lot of questions because the information in the PCA that they're claiming came from his phone shows him leaving his apartment at a certain time, and that's way after midnight. And we can't say that everything in the PCA is false information because some of those warrants did come specifically for information specifically for Bryan Kohberger, right? So when it comes to his phone, that's his phone data. That's not from like a tower just like by itself. Like it was all double checked, triple checked back against his actual phone data once they knew who they were looking at and had his phone number, which they tell us how they got all of that information. So it's all stuff that we definitely have to go back and look through. In fact, the defendant's travels during that time are described in the original probable cause affidavit supporting the criminal complaint in this case. Yes, that's what I just basically stated. As to the defendant's reference to potential testimony about the location of defendant's cell phone on the morning of November 13th, 2022, this information does not rise to the level of an alibi at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. The location of defendant's cell phone at times other than the time of the homicides is not proof of or relevant to the defendant's specific location at the time of the homicides, which is, according to this, approximately 4 to 4:30 a.m. on November 13th of 2022. Now, they've already tripped me out with a little 5 minutes extra that they're giving us based on the roommate's cell phones, okay? Versus the time they're claiming that the white car left. There's a whole 5 minutes difference. Now, homeboy just put a whole nother 5 minutes on it. Why would you do that, Xana? Why? It is the state's position that the defendant's continued failure to adequately comply with Idaho Code 19-5191 does not trigger a response under Idaho Code 19-5192. If the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code 19-519, then states request additional time pursuant to Idaho Code 5195 to prepare a list of witnesses to establish the defendant's presence at the scene of the homicides. So the state now is asking for additional time to find people who can claim that they physically saw Bryan Kohberger at the scene at the time of. That would literally only be Dylan unless we've been lied to this entire time, which is entirely possible. And I really wish that we've known by now if they ever did like a comparison photo, like before they arrested him, did they pull his photo from his ID and send it over to Dylan's attorney and be like, hey, we need her to look at this picture? I would love to know. I would love to know. But that's what this sounds like. And again, unless we've been lied to this entire time, which is entirely possible, the only person that would be Dylan. Because we're being told nothing about Bethany seeing anything. Not with her eyeballs. At least, right? At least not by the police. So, interesting. As to witnesses to rebut a claim of alibi, the defendant's failure to adequately comply with Idaho Code 19-519 means the state does not know what specific assertions it needs to rebut. If the court allows the defense to offer further witnesses or information regarding alibi, which the state opposes as described below, and bring it into compliance with Idaho Code 19-519, the state will then respond accordingly pursuant to Idaho Code 19-5192. So they've already said that they don't want him to just like pop up some evidence at trial, which I understand because you're not supposed to just do that, okay? And if it could have been proven this whole time so easily, then why haven't you done it already, all right? But then again, it is not abnormal for people to be alone and not have anyone to vouch for them. Okay? It's not. It's not. There is really no reason to sit here and think that his alibi is so far-fetched other than for the people that are being really stupidly sarcastic about things. Because I see people like the Vinny guy from, I believe it's like Court TV or whatever, and he's sitting here, he's just like stargazing, staring at the moon. You know, Nancy Grace be doing the same stuff, all right? That's not really what it says. It just basically says that he has a behavior of going out at night, driving around at night. He has in the past taken pictures of the moon and the stars and the sky whenever it's been real pretty, and he has wanted to take a photo. But that doesn't mean that's what he was out doing that night. Now, he could have just been out driving, clearing his head. Okay. It was getting close to the end of the semester. He maybe wasn't going to be going home for Thanksgiving break coming up. It was also Parents' Weekend at WSU, and it doesn't seem like his parents went, right? So maybe he really was just driving around thinking because he was alone while everyone else was with their parents and out having fun, and he wasn't. He was driving, thinking. Late night behaviors are very normal for Bryan Kohberger. We heard about it from the very beginning, from him going on night runs with friends to him being up and vacuuming at 3 or 4 o'clock in the morning. Some people can't sleep. Some people have insomnia. Some people have a lot on their minds. Some people are night owls. Some people just don't sleep the way that other people do. Okay? I know quite a few people that go out and just drive around in the middle of the night by themselves. Now, when it comes to you being the suspect of a quadruple murder, it would probably be more beneficial to try to think of something. Okay? You have to, because you can't just sit there and expect for this to not be an argument. If you're by yourself and you have literally nobody that saw you leaving, nobody that saw you going, nobody that was there with you, nobody that you met up with, yeah, this is going to be a tough fight. And for people that have like questions about, well, why did he even waive his right to a speedy trial? Well, honestly, if you knew that you were alone and your phone wasn't on network because it was either dead or where you were was so mountainous and full of valleys and out in the middle of nowhere that you didn't have any service, would you not want all the time that you possibly had to try to prove that you were innocent because you know that you are? I mean, I can see both sides here. I can see people saying, oh, he's guilty. He's just trying to make them prove it, which, yeah, they're supposed to. That's kind of the whole point. Or he could be innocent and he's trying to make sure that he has all the time in the world to prove it. What's a few years if your life's not lost at the end of it? Yeah. It has now been approximately 11 months since the state filed its request for discovery disclosure alibi demand on May 23rd of 2023, and almost a year and a half since the homicides occurred. The defendant has been given more time than he is legally entitled in order to provide his alibi. The state is substantially prejudiced and compromised in its ability to investigate and respond to new or additional alibi-related disclosures. As the Idaho Court of Appeals noted, the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. The state respectfully submits that we essentially remain in the same position as in July and August of 2023. And he cites this case law where it's State versus Juarez, and he's basically like, we've waited all this time and we have no new information. And honestly, that's sort of like the same sentiment that the Goncalveses have with it too, that they've been waiting and waiting and waiting, and then they were like, what is this? What is this? And yeah, a lot of people felt like that, and I sort of felt like that at first too, but then you really get to thinking about it, and you're like, well, homeboy was by himself, so what else are they really expecting him to come up with? As the state further noted in its July 27th, 2023 motion to compel notices of defense of alibi, or alternatively to bar certain evidence, the United States Supreme Court has observed in Taylor versus Illinois the ease with which an alibi can be fabricated, and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. I mean, I don't disagree with that either, because people have questioned that. Like, he's only saying that he's going to prove his alibi based on all of the state's evidence. He's going to use it against them, blah, 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 because he doesn't have one, and he's just trying to figure it out because he thinks he's so smart. He thinks he's the smartest guy in the room, so he's going to take all the discovery, and he's going to try to weave it into an alibi for himself, even though it's a lie. Maybe. Maybe. But that doesn't mean that the state does not have the legal right to hand over everything that they have in discovery. Things are not supposed to be being withheld. You're not supposed to be putting somebody in front of a court for the death penalty for a quadruple homicide without making sure that you have all of your evidence. Do we even know if the cast report is complete yet? Do we know if Ann Taylor is satisfied with said cast report? Do we know if everything else that was supposed to have been obtained from other agencies has been obtained by the state and handed over to the defense? Do we know any of that? No, we don't. Based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add any purported claim of alibi and preclude testimony by anyone other than the defendant as to the defendant's absence from or presence at the scene of the homicide. If Bryan takes a stand, I'm going to be floored. After all of this standing silent and how I kind of feel like they've been sort of keeping to theme with the whole standing silent thing, because even with this whole like alibi stuff, she's like, well, your evidence is going to prove that this alibi information that we're telling you is legit. And if you refuse to hand us over the other things that we know exist, then we're just going to say they're exculpatory and you've done this on purpose, which very well could be the truth. So now we have a temporary order sealing exhibit. What exhibit is this for? Okay, yeah. Temporarily sealing the defendant's fourth motion to compel exhibit attachment thingy. And then we have this notice of hearing, and it is for 5/2. Oh, holy crap. They're doing that this week. 5/2. What is today? The 29th. Tomorrow is Tuesday, the 30th. It's a freaking court date in my own situation there. Nothing important. Still waiting. Still a waiting game. Still stupidity. Still allowing this idiot time to do stupid, idiotic things. But I digress. So this is going to be this week, I believe, Thursday, 10 a.m. And it will be live streamed. It says motion hearing, state's motion to close hearings and defendant's objection. So they're having a hearing about the fact that the state wants the hearing on May 14th, 12 days after this 5/2 hearing, the fact that they want it closed. So we know that normally we don't get decisions from Judge as soon as sessions are done, ever. Like, he never just pops the gavel and makes a choice, literally ever. So we probably won't get an answer to if that's going to be sealed or not until probably the beginning of next week with some document that gets dropped. That's normally how that works. But yeah, that's it. That's all of the documents. I'm so glad my freaking internet came back up because this was going to be a lot to try to catch up with. But now they're here. They're there. They're going to be posted. They're out there for you guys to look at. And as always, the link for the Idaho Judicial Case of Interest website will be in the description box so that you guys can go and look through all of these documents yourself if you so choose to do. But that is it. And I want to know what you guys think down in the comments. If you like the way that I present this information and give my opinion, please not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.